What is a separation agreement, Rob?
Sure, absolutely. And Cliff, before we get into that, I also wanted to point out because it segues very well from your topic into our topic. There is constantly legislation that's proposed in Michigan dealing with these mass layoffs and what you may have to give people, right? For example, you have House Bill 5890 right now, which if passed, right, it's still obviously in legislation, would require certain severance benefits,
Sure.
if you have those sorts of mass layoffs that's out there. So it's something to pay attention to because what we're going to talk about is more of the voluntary, severance agreements, right? You don't have to give people severance agreements, right? Or severance payments or bonuses unless you have, a contractual requirement to do so. But there's some legislation coming down the pipe, potentially, that may alter some of the things that we're talking about. So I do advise everyone to kind of keep their eyes open because this is an issue that is getting a lot of attention, a lot of traction here. So turning to your question, what is a separation agreement, right? Separation agreement is just an exit contract, right? If you have an employee that you're terminating for whatever reason, whether it's one or a multitude of them, you always have the option, and they also have the option of refusing, of negotiating certain exit procedures, right? And those procedures can involve, the payment of money. They can involve, the payment of certain, ongoing expenses. It can involve, things like restrictive covenants, circling back to our first topic of the day, right? Maybe we need to plug some holes, in the documents that are there, or something has changed and we want to make sure to protect the company, whether it's through a non-compete or a non-solicitation, right? And in order to do so, we're going to offer to pay certain amounts of money, right? So a separation agreement is really just the agreement that parties are going to live by in order to walk away from each other. It involves often the waiver of certain claims, the acknowledgement of certain issues, right? Um, the requirement to turn in all of the company property or the acknowledgement that that company property has been turned in, right? So again, it's that standard, and I don't want to say standard form agreement because none of them are ever standard, but it's a standard type of exit agreement that we would enter into when there is someone that we want to make sure is covered by those post-employment covenants and terms and conditions.
And that's a great segue to Carl. I want to ask you a couple questions about separation agreements. When we were talking about laying off people, when we were talking about mass layoffs or an individual layoff, you can do it in a mass layoff. You can have a person get laid off because there's a lack of work, but we want to make sure we have our reasons for doing that. One of the things mechanically you think through is, do I want to give the person a separation agreement, right? You don't always have to, is my understanding, right? It's not required that whenever you lay somebody off, you do. So the question is, when would you want to enter into a separation agreement? Because they're not required by statute yet. So when will we do it?
Yeah, great question. I guess I would just follow up on what Rob said a little bit in terms of, what the separation agreement really is. And I think in its the way I look at it in its simplest form, it's really a document that is intended to tie up all loose ends with that employee. I think about the separation agreement as something it's you really want a clean break with the employee, no loose ends, ideally no ambiguities. So when that separation occurs, everything is predictable and essentially controlled. And really what you want to do is avoid lingering issues. So you don't, as you said, Cliff, you don't always need one. You don't always want one. But in my experience, and my clients who are on this call may have heard this before, is that I really look at there's usually three reasons why you would enter from the employer's perspective. There's really three reasons why you would want to enter a separation contract. And one is that the employer is concerned that the employee might sue the employer. So that would be a case where either the employee has already threatened a lawsuit, or there might be some facts surrounding a termination or even a potential termination, where the employer feels that they might get sued by the employee. It could be a discrimination claim. It could be any multiple kinds of claims. But if the employer feels they might get sued, and so there might be some liability exposure, the employer's goal, the reason they would enter that separation agreement, is to get a release of all legal claims that that employee would have against the employer. And we typically like to include not only claims against the employer, but the owner of of the business. Even if it's a corporation, still, the owner, the officers, anyone associated with the business, other employees. Again, the idea is to tie up all those loose ends. And here the goal would be to get a release of those legal claims. The second situation where an employer might want to enter a separation agreement is if the employer wants something from the employee that the employer does not already contractually have. So where I typically see that is if the employer is seeking a promise from the employee not to, for example, poach customers, not to solicit customers. You guys talked a lot about non-competitions and non-solicitations. I've been in several situations where an employer didn't have a non-compete, did not have a non-solicit, but now it's very important. They wish they had. And so the employer is willing to pay a little bit of money as an exchange in order to get that promise to not from the employee to not compete or not solicit. I will, it's not unusual for an employer to seek a non-disparagement promise from the employee. So the employee's concerned that, or the employer rather is concerned that the employee is going to go out into the marketplace and badmouth the employer. Sometimes it's worth it for the employer to pay some money in a separation agreement in order to get that. Sometimes an employee might have the secret sauce, so to speak, the secret formula. Employer realizes when they're terminating, gosh, I wish we had an agreement where that secret sauce is not going to get shared. So you can include that in a separation agreement. And there, the goal is to get that thing that the employer wants that they didn't already contractually have. And underlying all this is another way to look at the separation agreement is it's a grand bargain. It's a grand bargain where each party is getting something they don't already have. Usually what the employee is getting is money. Sometimes it'll be a continuation of healthcare benefits, but it's often money or a continuation of healthcare benefits. It could be other things, but so that's what the employee gets in the grand bargain. What the employer gets in the grand bargain is that thing that it doesn't already have, a release or maybe a non-compete agreement. Then the third, and by the way, it's normally the release that the employer's after. Less likely is that the employers want this thing that they don't already have. The third situation where I would say, okay, let's go ahead and to an employer and say, let's go ahead and try to get a separation agreement done is sometimes employers just want to be nice. They want to be good doobies and they want to reward a longtime employee, a really loyal employee, an employee that's been really beneficial for the company. And they say, hey, can we give this employee, this departing employee, some money? And of course, the employer can do that and doesn't have to get a separation agreement in exchange for that money. But my view is as long as the employer is giving something it doesn't have to give, this bonus or this gift, whatever, there is a chance that a couple of years after the separation, after all the good vibes wear off, and the employee is talking to their cousin lawyer who says, boy, did they really treat you fairly? I mean, you might want to, and you might want to think about. I think that there might be a claim there, and then so even though there were all these good vibes at the departure, still sometimes those employees will come back and then make a claim. So my view is, as long as the employer is giving this gift, you might as well get the release of claims in a separation agreement in exchange for that. And you can, you don't have to do it in a confrontational way. You can say, look, we want to give you this gift, but the pointy-headed lawyer, Karl, says, hey, we want you to sign this thing just to kind of document it or whatever. So in those cases, I would get the release, in the sort of a just in case situation. So those are the typical reasons why an employer would want to enter a separation agreement.
Yeah, great considerations. Now, I guess to sum this up, have there been any recent changes that employers should know about what to put in their agreements, or if there's any challenges? I guess I asked both of you that, like, what's a way to make sure we get these things enforced? Because we don't want to put language in here, have everybody go through all the effort of doing it, and then having it overturned because of some development.
Well, Rob, unless you want to jump in, I guess I would say for what I've been keeping an eye on and what I think the relevant changes are, and these are important changes. They're not like huge enchiladas, but it's enough there that you need to definitely keep an eye on it. Is there have been some changes very recently regarding confidentiality clauses, non-disparagement clauses, and cooperation clauses. So just a little bit by way of background, I won't go too far in the weeds here, but for many years it was very typical for separation agreements to include clauses that, for one, prohibited the employee from telling anyone about the fact that there was a settlement or the financial terms. We call that's essentially called a confidentiality clause. It was typical to include a promise from the employee that they weren't going to say bad things about the employer in the marketplace or about its owners or its services or its officers. We call those non-disparagement clauses. And then it was also quite typical to include clauses that required the employee to cooperate in future investigations or proceedings involving the employer. So the employee leaves, MIOSHA comes knocking, or the EEOC comes knocking, or the DOL comes knocking, and that employee had important information, and we really, the employer needs that cooperation. So these separation agreements would say, hey, if something like that happens, you gotta essentially come back and help us. So those were, and employers generally liked these three clauses that I'm talking about, and that changed in 2023. And essentially, the General Counsel for the National Labor Relations Board issued an opinion which essentially stated that the General Counsel believed, and the General Counsel is sort of the sheriff, that's the person that's sort of enforcing the National Labor Relations Act. She came out with this opinion that said, hey, look, many versions of these clauses that I was just talking about were either unlawful or they were likely unlawful under the National Labor Relations Act. And the General Counsel set out a new test that essentially made it harder for employers to enforce these clauses. And the real kicker is that this sheriff, the General Counsel said, those rules that I just described, less employer friendly, those apply retroactively. So even if you had those things signed when they were lawful, now they're unlawful or likely unlawful.
Does the NLRB exist? Are we sure that they're actually still there? There's been a lot of developments going on, so I don't know if that actually matters right now. I mean, I think they are in existence, but who knows?
Yeah, no, they're still there, but they're certainly changing. To your point, I mean, many of these issues that we're talking about here, they're really political footballs, and so when the administration changes, they'll change the people on the National Labor Relations Board. To your point, the laws themselves usually actually stay the same.
Yeah.
It's just the interpretation and who's doing the enforcement, the General Counsel and the DOL. They will change. So back when this thing changed in 2023, we basically, and you maybe have read some stuff that we wrote, we began advising clients to take these clauses out or at least rewrite them, and to stop enforcing existing clauses that were good when they were written in older separation agreements. And then in this February, new administration, obviously, new sheriff, new General Counsel, went and basically rescinded all those 2023 Biden era general counsel interpretations regarding confidentiality, non-disparagement, and cooperation. And there was they also the new administration also rescinded another memorandum which had signaled that the National Labor Relations Board would vigorously seek damages for these unfair labor practices. So to your point, Cliff, I mean, they're still there, but the recent messaging coming out from the general counsel's office by rescinding this aggressive enforcement approach of the Biden administration has basically been, we're here, but I mean, I'm burlesquing this a little bit, but they're essentially saying we're here, but you don't have to worry quite so much about certainly the way things were, in the Biden administration. So the temperature, the tone, the color of all this has sort of changed to where like you say, Cliff, that it's still there, but it certainly looks like a different animal than it did, not too long ago. So the
And
punchline here,
fundamentally,
what's that?
well, and what I was going to say is fundamentally, we've talked a lot about, the government enforcement and the government regulations. And I don't want to forget that, enforceability also is a contractual issue, right? You need to have all the things that we were talking about beforehand, reasonable restrictions, consideration, all those sorts of items. But one thing that I really don't want people to forget is when we're trying to figure out what needs to be put into the agreement is the legal obligations based on things like age, based on the things like the number of people that are out there, right? If you let go of a certain number of people above a certain age with that Older Workers Benefit Protection Act, you have other obligations you have to jump through. You have other hoops that you have to jump through, other disclosures and things like that are out there. So, again, we spent a lot of time talking about the ping pong effect with the government agencies, which obviously, it happens. Any administration change is going to change those areas that are out there. But it's also really important to note that the separation agreements aren't a cookie cutter for every single situation, right? You really do have to evaluate the facts and circumstances on it. So.
Yeah,
Rob,
fair enough.
yeah, I think that's a great point.
Yeah, I mean, yeah, right. They're not, we get phone calls from clients that say, can you just give me like the separation agreement? I'm sure you have one on the shelf. I got to tell you, I have so many different kinds of separation agreements. There's some situations where you want it as simplistic, as few words as possible. You don't want to spook anybody, so it's just so there's some like really bare bones separation agreements. And then as you go up into the C-suite, the separation agreements tend to get much more complicated. In those situations, there might actually be an employment contract that talks about separation agreements and some of the terms of the separation agreement. And so that can change. And to, Rob's point, essentially anytime you have a program, which is really two or more employees that are terminated as part of a program, you need to keep an eye out on getting appropriate releases for age discrimination claims. So when you have a program where two or more people, you have to include special data. And this is something that you absolutely have to call an attorney about. There's some specific data you have to include to get release of the age discrimination claims, like what's the department or unit that is being looked at for the reduction in force. What are the job titles of the people that are being let go? What are the age of or might get let go, I should say. Then the job titles and the ages of the people that are actually let go. And then on top of that, there's magic language that has to be included to release these age claims. And this is really a bugaboo, the age, this is a pitfall. This is something that you need to look at is that if the person is 40 or older, which, to me sounds quite young, but if they're 40 or older, one, there's magic language you have to include in the release. Two, you have to give them 21 days to consider the separation agreement or the release, really. And then they have 7 days to revoke. It's very easy to get tripped up on these things I'm glossing over some of the complicated issues that come up in terms of, oh my gosh, now I have to wait 21 days for this person to sign. Well, I mean, you have to give it to them, but they don't have to use it. And this is often a sort of a confusion when you're trying to land a separation agreement. But just
Oh, that's a really good point because I know you draft. Unfortunately, you and I and Rob and a lot of our team here, we have to draft these all the time. You know, people get let go. We do them for a purpose and a reason. But sometimes employers will go out there, they'll just have their standard agreement. They'll have a 35-year-old person they let go and they want them out. They want this thing signed, but they'll have an old agreement sitting around with a 7-day revocation period. So I can sign it now, but then I'm out. I have buyer's remorse. Well, why did you have it in there? And next thing you know, they get out of it and you're in a lawsuit.
yeah, yeah. I mean, yeah, there's lots of ways to trip up on that those special rules for age discrimination. The other thing I don't want to take up too much time here, but in terms of like where the pitfalls are, the things to keep an eye on when you're doing a separation agreement, I'll just give you a short list of things to be thinking about, and often come up in when we're drafting these. And for those of you on this call that have worked with me, you'll know I go through a lot of these issues with you. Is do you want to characterize this separation as a voluntary resignation? This is something that you can costs you very little, but could be a value to the employee. So this is in the category of what's the employee getting out of this? Again, I said it's usually money. It could be a continuation of healthcare, but sometimes it's like, hey, I just want to be able to say to the outside world, I resigned and I wasn't fired. It might be, look, I just want a good reference letter or a neutral reference letter, or like, hey, I want to know when I list you as a job reference that I know who's going to pick up the phone over at the employer and what they're going to say. So these are things of value to employees that you can negotiate in these separation agreements. There's issues related to unemployment. You can sort of, how you write the separation agreement can have some impact not only on whether unemployment will be paid or not, but essentially a discount on the payment of employment benefits, depending on how you structure the severance payments, whether it's lump sum or whether it's over time. You want to be thinking about things like return of property, those clauses that I talked about, confidentiality, non-disparagement, cooperation.
And I also think that it's important for us to consider, what I think our next topic is going to be, the DEI and how some of the changes in the surrounding landscape regarding DEI may impact our desire to get into these settlement agreements and severance agreements and triggering the negotiation of those provisions.
Yeah. No, that's definitely something we want to look at, and I think we want to transition. And Karl, Rob, I appreciate it. There's a lot to this. I think people sometimes forget the nuances, so I appreciate again glossing over a lot of the details that have to go into this.